So, if you are ready, I wish to introduce this press conference about the British colonial land and human rights abuses in Kenya, UN Complaint for Justice and Compensation. And I wish to thank the organizer of this press meeting and the participant speakers, Professor Paul Shep-Kwoni, who is the governor of this region, Mr. Kimutai Bosek, a Kenyan lawyer, and Mr. Rodney Dixon, coming from London, from Great Britain, also to speak about this important topic. So thanks again. Welcome to Geneva and to the Press Club. Before to give you the floor, I wish to ask you to sign our golden book. Just a signature there, as we do.
Name and signature?
Yeah, yeah.
Okay.
All the speakers are asked to sign our book. Yeah. And we will start with the presentations. Okay, so thanks, and you will introduce. So have a good press conference.
Hello?
Aha,
yeah. Perfect. Thank you very much. Thank you so much for having us here today at the Geneva Press Club. And thank you all for joining us from quite varied places around Europe, and obviously to our speakers who have come today. It's a really great and important day today. It's bringing us one small step closer to achieving justice for the many thousands of victims of British colonial rule in Kenya. Of course, we cannot advocate for every single one of them. But many of them are still alive today. Something that many people forget is that colonialism in Kenya only ended in 1963, which is really only 57 years ago. And that's, you know, a lot of the victims and the scars still remain to this very day. So thank you very much for coming along to this important event. Speaking today, we have the Governor of Kericho County, His Excellency Professor Paul Shep-Kwoni. Kericho is the county in Kenya about which today's complaint, which we have filed at the UN, is about. Kericho, as many of you know who are Kenyans, is a very rich, arable part of the country. A lot of tea is grown there. In fact, the majority of the tea is grown there. Kericho is famous for that. And so the governor is here today to represent his people and to tell some of their stories and how we got here today. We also have speaking today Kenyan advocate lawyer Kimutai Bosek. Mr. Bosek has been working tirelessly going through, you know, everything from the colonial archives to gather all the evidence, the historical evidence of the abuses, as well as with his team on the ground in Kenya, interviewing the now roughly 115,000 victims that we have signed up to this complaint. And then finally, we have Mr. Rodney Dixon, who is a Queen's Counsel lawyer from London, from Temple Garden Chambers. Mr. Dixon is a very prominent human rights lawyer. He's acted in cases all over the world. And he will be speaking to us today about the international legal means that we have to try and resolve this historical injustice and, you know, try and make it a small bit better. So thank you all today. Finally, at the end, we're also going to have a short video, which is an interview with a victim from the Kericho region, and he is just going to describe, you know, some of the injustices and horrific human rights abuses that he faced during British colonial rule. So thank you very much for coming here today. We'll have time for questions at the end if you have any. And with that, I will hand over to our speakers, with the Governor starting first.
Thank you very much, ladies and gentlemen. As you've heard, I'm the Governor of Kericho. My name is Professor Paul Kiprono Chepkwony, and I'm here on behalf of the County Government of Kericho, as well as on behalf of the Kipsigis and the Talai, who have voted for me 2 times now as their governor. I'm also a victim, being a descendant of the victims of British atrocities against the Talai and the Kipsigis of Kericho. I would like to say that this particular move that has been made today, where we've submitted complaints at the UN Human Rights Council on behalf of the Kipsigis and the Talai, is a very, very important move. These people have suffered for a long time, more than 100 years. They've been crying for justice. It's never come, and we hope that this time something will happen. In collecting views from the people, and as a victim, and also having seen my parents and grandparents go through sufferings, I can confirm that the British came to Kericho and took land by force. They never bought it, and they still own that land to date. And I want to confirm that the multinational companies in Kericho are making a lot of money. They are earning a lot of profits. All that profit is extradited to the United Kingdom, and nothing is remaining with the locals. There is a lot of poverty among the Kipsigis and the Talai. Number 2, in taking over the land by force, they burnt houses, which is first and foremost against the African culture and the local culture. They took away animals by force. So many cattle were taken by force. They destroyed sacred areas, including areas where passage of rights for the children were held. They destroyed monuments. And the men who resisted this forceful acquisition of land were lined up. In fact, 1905 in Sotik, out of 8,000 young men who resisted, 1,900 were lined up and massacred with gunshots, and these are issues that must be addressed. Kericho is one of the leading economies, is the leading contributor to Kenyan economy, but the people are suffering because of this particular historical injustice. So we are here to tell the world that first of all, at independence, the land in which the multinational companies are sitting should not have continued being the crown land. Yet, this never happened. At independence, part of Kenya became independent. Kericho did not become independent. So we are here to tell the world that the victims are suffering. What they demand is apology from the British government and reparation, compensation, so that they may be better than they are today and catch up with the rest of the communities that did not suffer as much atrocities as the locals. Finally, We are determined to go all the way. We will leave no stone unturned until there is justice for the people. And particularly, there are communities within and families within the Kipsigis and Talai who were forcefully delocalized, taken to far places. This is against human rights, where we have relatives being put together so that they may not get married and expand the population of their communities. There are particular communities of the Kipsigis who are forced to disown their culture and become Samburus. This is something that is against international law. And these are some of the things which we are asking the court to investigate and take very serious action against the British government so that there may be no recurrence again. Thank you.
Thank you very much, ladies and gentlemen. As you have heard, my name's Joel Kimutai Bosek, and was tasked together with my team to collect and analyze all matters related to the historical injustices that were suffered by the Kipsigis and the Talai communities of Kericho, what was formerly Kericho District, which now became Kericho County and Bomet County. And when I embarked on this research, obviously I had some background knowledge about the issues affecting the people. I come from that community, and I heard from my grandparents how they suffered during the so-called the Kimulot murder. And it used to be just but a story. But when I was given the mandate, and I commissioned a number of researchers to conduct research in leading libraries within East Africa and also in Entebbe Archive, because Entebbe used to be the headquarters of the East African Protectorate. We went all the way to the Kew Gardens National Archives in London, went to Oxford University Library, and a few other libraries in the UK. And the story is the same. We interviewed more than 300 victims, and the story is the same, that the land belonged to them, and that that land was taken away from them forcefully. And reading on the materials from the archives, we were able to confirm and collaborate what the victims were saying. For instance, in 1905, 90,000 hectares of land was taken away from them in a place called Londiani, which is within Kericho County. There was no compensation. The British decided to remove the native population, force them into the so-called native reserves of Bureti, Sotik, and Belgut. When you look at the story of these reserves, ladies and gentlemen, as an historian, I believe that the Bantustans in South Africa during apartheid, started by Dr. Malan in 1948, appears to have borrowed from the so-called native reserves in Kenya. It appears that the apartheid regime borrowed heavily from the British. They were learning from the best. Apartheid could have been created in 1948, but the native reserves in Kenya came into being in 1907. It means that apartheid came in 40 years later. So actually, that was a form of apartheid, and nobody in the world appears to have drawn a parallel or to relate the so-called native reserves in Kenya and the apartheid regime in South Africa, the Bantustans. Secondly, land was taken away throughout 1907 all the way to 1919 after the First World War. And by the way, many of our grandfathers fought in that war, and they don't even know that it was called the First World War. They all will tell you that it was war against the Germans. They called the First World War the war against the Germans because the target was to kill the German in Tanganyika that time. And they speak so much about it. Obviously, most of them are very old now, and others have unfortunately passed on. And then for the Second World War, they say it is the war against the Italians. So when you hear them talk about the war against the Italians, they actually mean the Second World War. 5,000 Kipsigis men were taken to fight in Burma, including a brother to my grandfather, the late Kipkones Arab Bosek. I've adopted his name. And they fought for the British government alongside the British, other British troops. And when they came back to Kenya, the British saw the need of taking land away from them, even after serving them so faithfully. But in 1919, let me start with 1919, the British had soldiers who had gotten injured during the war. But to reward them and to make them have some form of occupation, they decided that they should give them 25,000 acres of land in Kericho. Very fertile land, very arable land. And then this is land which the British government misled the world into thinking that it was first unoccupied and wasteland. When they say land that is unoccupied, in other words, it does not have people, and wasteland, if you go to Kericho and see that land, if where the multinational tea companies is a wasteland, then the rest of the world is really a wasteland. And we are telling the British that we have gone into your archives. We have gone into your writings. I mean, there was this idea that if you want to keep something hidden from a black man, put it in a book. And I'm very happy that they wrote it, not knowing that there'll be a group of people seated today who will be discussing whatever they did. Kericho land that is under the multinationals is one of the richest, the most fertile, and the most arable land, not only in Kenya, but I believe actually in the world. And for them to call it unoccupied and wasteland, first of all, it was occupied. If I'm to name the 38 tea estates in Kericho, all of them bear the local names. You'll hear names like Chagaik, Cheimin, Tagabi, all the way they are 38. None of them has the English name. If it was a wasteland, ladies and gentlemen, perhaps they could have called it Sainsbury, Newbury, Slough, and rivers there could have been the small river Thames, like the Tare River probably. So we refuse to believe and to live under this kind of deceit. We have and we have had to bring very fraudulent nature of transaction that were done. People being given land. In 1963, when they were leaving Kenya, the British settlers, white settlers, who included some South Africans, those who never wanted to live in Kenya under a black leader, Jomo Kenyatta, were actually enticed by what many historians fail to appreciate. And let me say today and correct the record, that the British never paid the 100 million pounds that they claim. That was not money that was meant for compensation. That amount of money was meant to be a fund so that whoever was not willing, whichever settler who was not willing to live in Kenya will actually probably get some native Africans to buy that land because Africans were struggling. And this was a fund to allow the Africans to buy land from the settlers. And our historians have also failed us. In 1963, when we got independence, there was a mass migration of white settlers from Kenya to Zimbabwe. Nobody is able to link that move. The reason why Mugabe maybe died a crazy man is because of probably what he went through. In 1963, Zimbabwe had lost like 18 million acres of land to the white settlers. But up to 1980, when they got independence, the figure went up to 33 million. And most of these people who went to take up these 13 million acres or so are the ones who are leaving Kenya and migrating to Zimbabwe. And then in Zimbabwe, when they got independence again in 1980, a number of them left to South Africa. South Africa became a multiracial democracy in 1994. There was also some kind of migration to places like Australia. We are not hearing people being able to mention that. But that is for another day. I want to say this, that the British saw it fit to take land for free when there was actually a law which was adapted from India, the Compulsory Acquisition of Lands Act of 1894. That was not applied in Kenya. That was not applied when it came to the Kipsigis. When the Kipsigis land was taken for the railway construction, the railway land was supposed to be 1 mile apart. But for the Kipsigis and the Nandis, they were actually to move like 26 kilometers away. Unlike other communities in Kenya, they were not allowed to be anywhere near the railway. A lot of things were done. And I want to invite anybody to go to Kericho or even to come to us. We show you artifacts which we got from 51 sites within the tea estates. We were pretending that we were part of the people who are working for the tea companies, but then collecting broken pots, broken calabashes. Obviously, those don't belong to Europeans. They belong to Africans. Then there are places where you will not find tea growing. Now, those were homesteads where goats were kept, because I'm told tea does not grow in places that are, is it acidic or alkaline? Alkaline. And the dung from goats actually are alkaline. The British, we must applaud the American missionaries. For us to have gone to school is because of the American missionaries. I know other communities in Kenya went to school courtesy of the British. But for us, the British did not even want us to go to school. As a matter of fact, the American missionaries saw it fit to build hospitals like Tenwek. But when the British chased away the Talai, they could not even access the mission hospitals, which they never built, but which were constructed by the American missionaries. There was the so-called Highlands Bible College, which was supposed to be constructed in Chagaik. But the Land Control Board, which was mainly dominated by the British, were up in arms against the American missionaries, telling them go and construct that university, useless university, in the African reserves. In Kericho, Anglican Church only was started the other day, not by the British, because I realized that you cannot be preaching to somebody and stealing from him. Remember, the British and the Americans were both on a mission, but to do two different activities. The British settler was on a mission to take away land. The American missionary was on a mission to convert Africans and to probably improve his lifestyle. When I listen to songs by Lucky Dube, I think it appears that probably he was discussing about Kericho, because the condition Lucky Dube was talking about, when he says born to serve, when he says they are no longer building schools, or they are buildings, what they are building is prisons. In Kericho, the British are not known to have left any significant structure for the African people, unlike the American missionaries. We have the Kericho prison, which was built by the British in 1942. Was the prison useful to the African people? We have so many detention camps that the British built. People who were detained, people who were imprisoned, be they from Kisii, from Luo, from Luyaland, all of them will be brought to Kericho to assist the British government in burning Kipsigis and Talai houses so that white settlers could get land. And it's very unfortunate that the British have not seen the need to address that kind of an ugly history. Lastly, I wish to address the issue pertaining to the Talai victims. Talai is a central clan within the Kipsigis community. We live in clans, and inter-clan marriages is forbidden. This was known to the British, but they decided to take Talai people to remove them from Kericho, take them to a place called Kwasi, which I'm told actually that the Kenya government has set it to be a national park. In other words, that's a place that is only habitable for wild animals. It is infested with a lot of mosquitoes and tsetse fly. The first 3 years of Talai occupation in 1934 led to 100% miscarriage among the Talai women. In other words, they were not giving birth successfully because of the conditions there. And what is interesting is that in 1925, there is a report that was presented to the British House of Commons that actually stated that Talai was not a good place. It was infested with tsetse fly. Yeah, Kwasi was infested with tsetse fly. And it beats logic why in 1934, 9 years later, a responsible government will actually take people to a place which a commission had established was not fit for, it's called the Gore report. We have a Gore report. We have that report as part of our materials. I want to also say this, that Talai are not witches, the way the British government will want to say. They were removing them because they believed they were witches. And even during their removal, it beats logics. And it's actually they organized for a very bizarre kind of event, a ceremony, whereby 10 Kipsigis men, elderly men, were picked to take an oath. And they were made by the British district commissioner, who was also the Kericho district magistrate, making these people to drink water from a human skull. Human skull. I mean, somebody who has died, but the British saw it fit to use those skulls, and they are the ones who actually killed those people anyway, to use human skull so that, in other words, that kind of an oath will actually bind those people who are doing that. And we are saying we are not going to let this go. We are saying, and we are telling the British government in no uncertain terms, that we believe that the land is ours. We believe that you have benefited a lot. I know the Kenya government has started a program of investigating companies who are engaged in tax evasion, tax avoidance. But I must say, out of my research, that for a very long time, the British multinationals have been involved in what is called transfer pricing, yes, where they establish various companies outside Kenya, and then they sell the tea at a throwaway price because those are their companies, and that way the Kenya government is not even able to raise enough tax. There is a company that for probably almost 20 years now, it has been declaring losses. We are aware of that, and we are saying that we are not going to remain seated and watch them benefit heavily on resources that actually should be benefiting everybody else. I think I've said enough, and probably I'll address other issues during question and answer. And maybe as a very last thing to say is that the British will always want to pass responsibility to the Kenya government. But we have this to say, that after 1963, when we got independence on the 12th of December, the British government was responsible for Kenya. And that's why under the Independence Act, an act of parliament in the UK, that act says that UK will cease having responsibility over Kenya. So we are saying the British government was responsible up to the time we got independent. Secondly, we are able as legal scholars to distinguish between a protectorate and a colony. The land in Kericho was not taken away during the colonial era. I want to be very clear with that. It was declared crown land during the protectorate era. A country that is exercising protectorate over a particular region only exercises what is called foreign jurisdiction, but not domestic jurisdiction. But for the British, they went ahead to exercise domestic jurisdiction. But then now during the colonial era, that is when they decided to take or to alienate land, which already was a crown land. And we are very clear with that. And it's not the first time that people have kind of made an attempt to address this issue. In 1932, there was the so-called the Kenya the Kenya Land Commission, which was headed by Lord Maurice Carter, which went collecting grievances from the African people, and they were in Kericho, and our elders actually told that commission that the Kipsigis people were not happy because land had been taken away all from Londiani all the way to a place called, I'm forgetting, a place in Kericho with tea from Mzee Arab Miner of Belgut actually complained that land had been taken en masse. And they had actually suggested a form of arbitration, telling them that now that they were able to link them with England, a place they never knew, that go and tell the old men in England. They were actually asking for arbitration. When you look at it in retrospect, these elderly people never knew a lot. They were ignorant. They were not like the Englishmen who had traveled all over the world. So they were saying, go and tell the elders in England that we in Kipsigis land are not happy because land has been taken away. And we are, but that failed on deaf ears. That is the time, and in a case, that commission of Lord Carter had recommended that compensation be paid. We have not seen that compensation up to today. That report was submitted to the British cabinet in 1934, but I'm sure it's gathering dust. It's in the, anyway, it's in the archives. So we are saying that we are discussing grievous matters. When you see a number of people who have found themselves to Masai Mao, those are descendants of the victims. Others are direct victims who actually bought land from the Mao because they cannot buy land in Kericho, which is very expensive. Land in Kericho is very limited. Governor will tell you that because you'll find people staying in 0.1 of an acre, and that is a whole family of maybe more than 12 people. So we are saying that, ladies and gentlemen, this is a matter which we are calling upon the United Nations, which is actually the family of nations, to actually find that British committed historical atrocities and that they owe apology to the victims, that is the Kipsigis and the Talai. And we're also saying that reparation or compensation is quite apt. Thank you very much.
Thank you. Good afternoon. I'm going to talk a little bit about what we've done today in respect of filing a complaint with the United Nations. We have today over the road at the UN Human Rights Council, which is sitting at the moment, filed a formal complaint on behalf of our clients, the Kericho County, and over 100,000 victims from the Kipsigis and Talai communities, with the UN Human Rights Commissioner, but also very specifically with the Special Rapporteur on the promotion of truth, justice, reparation, and guarantees of non-recurrence. That's a UN position that was established in 2011 precisely to look at these kinds of situations where national governments have either refused to deal with the problem or have reached a point where it is not solvable. The Special Rapporteur can step in with the backing of the United Nations and under his or her mandate look to investigate the matter, look to get the states concerned together to negotiate and reach a settlement, and make specific recommendations about how the situation can be resolved. The Special Rapporteur can also provide technical assistance and expertise to allow that to happen, and very importantly can come to the country concerned and conduct a site visit to prepare their own report. That's what we're asking the Special Rapporteur to do in our case, because we've reached a stage where trying to negotiate with the UK government has not produced any concrete results. That's not to say that it couldn't in the future, but we have decided that it's in the best interests of our clients to elevate the matter now to the United Nations, to get the Special Rapporteur and other UN officials involved, so that there can be a resolution of this matter. You may recall that in the UK in 2013, there was a court case where a number of victims in relation to the Mau Mau uprising sought to sue the UK government for the torture and abuses that they had faced. And in that case, after the UK had sought to throw out the case on the basis of time limitations, but also because they said it wasn't the responsibility of the UK government, and those were rejected, the government then settled that case, paying nearly £20 million to a group of victims, the then Foreign Secretary William Hague saying he hoped that that would draw a line under the matter. But that was only one group. Our clients are in a different area, a different group altogether, affected by the same pattern of colonial abuse and oppression, but were never included in that settlement. And there's no way, as a matter of law, that you combine the entire group when they weren't involved in the first place. So we are saying that that process that was started and to be welcomed then by the British government should continue to all groups that have been equally affected. In fact, it's something the UN has said before, that the danger of some reparations to some victims is that in and of itself discriminates again. So not only have people suffered discrimination in the first place, but then in the way in which the remedy comes, you have the same form of discrimination later. So it needs to be comprehensive. It needs to be uniform. The UK courts have, since that case, blocked a number of other cases you might have read on time limitations, which many have argued is unreasonable given that human rights have no time limitations. They didn't suddenly come into existence in the 20th or the late 20th century or recently. If they exist, which they certainly do, they've existed through all time and apply equally. They are universal. So it can't be right that you have a cutoff point to when you can claim compensation. Certainly international crimes like genocide, crimes against humanity, war crimes have no time limitation. You can prosecute for them at any stage, and that has been recognized by the UN. So similarly, reparations for human rights violations we have submitted should not be cut off at any point. But having said that, we have decided that it would be a arduous road to try and proceed through the British courts with this case. There are a number of victims. It would take a huge amount of time, be very costly, and all kinds of legal obstacles can be thrown in our way. Litigation can become a messy business. Of course, we can always fall back on that if we have to, but our preferred route has been to look to arbitrate the matter and reach a settlement with the UK government. And this step is one going firmly in that direction, to take it to the United Nations for an intervention. That being a much swifter way and potentially a much more effective way of resolving the problem. So we have got together all of the evidence from hundreds of victims, the documents from the National Archives. We've got psychiatric reports and evidence as well to show how people continue to suffer today and to show the personal injury, the damage, for making out a case for reparations in respect of individuals as well as groups. And that has all been put before the British government and now before the United Nations. The next step, so you know what could be expected, is that will all be examined, of course, by the Special Rapporteur and the UN here. And we will be looking to encourage the Special Rapporteur to visit Kenya, to see it firsthand, to see the stark differences between walking around on the tea plantations and then going to where people live. There's nothing more evocative than being able to firsthand see exactly what the colonial period has produced and how it continues and has not been remedied. To interview the victims, to look to gather as much information and ensure that all parties, including the multinationals there, the British government itself, is consulted on what can be done about this. And for the Special Rapporteur then to offer their technical assistance and advice in how to deal with the situation. This is not something that is new. The Special Rapporteur has got involved in many situations previously, and situations going back. So there's no prohibition against retroactive application. The Special Rapporteur has been involved in inquiries regarding the Spanish Civil War, regarding the Second World War, regarding the troubles in Northern Ireland, events in Burundi, events in El Salvador. There have been a number of situations where the Special Rapporteur has got involved, conducted country visits and made findings and made recommendations for those states to be held to. So this is a precedent that can equally apply here, one that readily is applicable, we say, and that's why we have sought to initiate this today. We will be now looking to engage with the UN to provide all necessary evidence and to get the process going as soon as possible. Of course, at any stage in this process, the UK government can sit down with us and look to resolve matters. So far, there's been a refusal even to meet, which frankly we found astonishing on behalf of our clients, that there hasn't even been a readiness to engage on the subject. Now, there might well be a concern about what this opens up, but then that must happen. One can't sweep this under the carpet, hoping that it'll go away and that people will forget. Because yes, there are only a few direct victims still alive. That's one of the reasons why they're bringing it now, because they want to try and get justice before they die. But it will pass on to their descendants, and the conditions in which people live don't go away. So it's not going to suddenly disappear. Far better, we say, for the UK government to confront this now, to deal with it in an open and transparent way. That's certainly the trend worldwide, to look at not closing the book on matters when they haven't been properly investigated. Far better for the future to deal with the past, to get the truth about what happened, and then to look at building on that. And certainly, you might think for the UK government in its current predicament, looking at building partnerships around the world, that is going to be hampered severely if it is unable to build trust in places throughout the world, including in Kenya, where it has a colonial past. And to try and shift the responsibility to the present government is not going to work as a matter of law, but also logic. As has been explained, these parts were either under a protectorate or then a colony. They were clearly effectively controlled by the UK government. And even if they were controlled with others there. We have in criminal law, as you know, or in civil law, joint criminal enterprise, where you can be jointly responsible with persons. And at the very least, there was a common design that the British government was benefiting from and is therefore responsible for the violations that were committed. So there are a number of legal theories that apply to the situation, together with the logic and morality of the circumstances as well. But as a matter of law, there is a clear line of state responsibility for what has happened. We've set that out in the submission. The last thing I want to highlight as well, which we've put into the complaint, which is very important. Often people say, well, you know, what is the law that was applicable then? We know what it is now, but you know, what standards were we operating under then? And you know, we've made very clear that throughout that time, international human rights law was applicable. This was the time at which the Universal Declaration of Human Rights was being adopted right here in Geneva in 1948. And it was always said at the time that these rights have always existed. So the Universal Declaration was in place. That was law at the time and going back. Likewise with Nuremberg, you'll remember the Allied powers all said at that time that we have always, as the world, outlawed these kinds of atrocious acts. That's how they got jurisdiction to try the Axis powers, is they said that these crimes have always existed, going back to the Hague Conventions in the early 1900s and even before that. So it would be disingenuous to say that somehow the law didn't exist then. The UK was also going into the European Convention of Human Rights at a later period, while the colonial period was going on, and made that convention applicable in Kenya as well. So there is an abundance of law which made it very clear that acts which involved alienating land from persons without any lawful basis, and in the process committing both war crimes and crimes against humanity, were outlawed. So not only the taking over of the land, but also the way in which it was done, the crimes that were committed. We have outlined in our complaint a number of instances. Obviously we haven't been able to deal with them all, but of truly horrific killings, of rapes of young girls, of situations where parents were separated from their children and never seen again, houses burnt, complete destruction, and an inability to ever then return, and then imprisonment and detention to stop people moving around. Quite harrowing accounts that people still alive today are able to give, or give through their descendants. So that evidence is all before the UN. It will require further investigation. There'll be many more statements, but it certainly hits home how egregious the violations were, and therefore the demand even now, many years on, for justice. I just want to end with what was mentioned. The Kenya National Land Commission has made findings in respect of our case. We made submissions before the commission in Kericho, and it made very clear recommendations which came out last year. I just wanted to highlight 2 or 3 to show what really this year, yes, it came out this year, to show really what the UN should be following up on. The Land Commission said that the British government should apologise for the various forms of injustices inflicted against the Kipsigis and Talai victims that led to, amongst others, loss of their ancestral land, that the Kenya government should make a formal acknowledgement that what was Crown land was unlawfully taken from the Kipsigis and Talai by the colonial, that was taken by the colonial government, ought to have been surrendered to the community at independence, that the British government and the multinational tea companies are requested to construct for the Kipsigis and Talais amenities such as schools, hospitals, roads, museums, universities, and provide other services such as water and electricity that would alleviate or compensate their suffering, and that the British government should pay reparations to the direct victims of the historical land injustices. These were very clear recommendations that were made based on evidence and hearings. The report is all available. We've given the report to the UN as well. They are based on cogent findings in respect of the available evidence, and our plea is that they are now taken forward by the UN and ultimately the UK government to be implemented, not only in relation to land injustices but the human rights violations as well. Thank you very much.
Thank you so much for that. I'm going to play a very short 4-minute video, which is an interview with one of the many people who suffered greatly during the colonial period. And indeed, this gentleman, he talks about how he was removed from the ancestral land and taken to a region called Gwasi. So I'll just play the short 4-minute video, and then we'll have time for 1 or 2 questions after that. So thank you. I don't know if we can dim the lights. Yeah.
Tribe or clan. Tribe. I was born 19. Tribe or clan. Tribe. I was born 1948 in a place called Gwasi. In Gwasi, my village is. My mom is called. My mother is called Takigen Mvenge. I was born in Gwasi, the way I've said, and I went to school in Gwasi. But before I went to school, when I was born, after 2 years, I was affected by polio. Due to bad sanitation, I was affected by polio. Due to bad sanitation, a lot of cystic lice, mosquitoes, and snakes. Now, when I went to school, I went to Gwasi with a lot of complications because of disability. And I never went in a proper way. I went up to standard 4 by then. In fact, when we were in Gwasi, there was a lot of complications because of the place is a bit hilly, a lot of animals, hyenas and all those things. Main problem is that I never went in a proper way. I went up to standard 4 by then. In fact, when we were in Gwasi, there was a lot of complications because of the place is a bit hilly, a lot of animals, hyenas and all those things. Main problem is that they were not allowed to come to Kericho. There was a terrible issue which happened again because she never had any permit, so she was arrested. And she was charged escaping. So she was jailed for 6 months in Kisumu. And at the same time, I was still sick. So I was taken by prison wardens and I was treated when my mom was in jail. So after mom coming from jail, because I was 2 years by then, we were taken back to Gwasi. My father had a problem, so also he was jailed for 4 years. So when he came out from jail, my mom and other whites, because my father had 6 women. Yeah, there was a lot of problems because my father was in jail again. So in fact, what happened is that after going to school, in 1960, we came to Kericho. We squatted here in Kericho, and that's the time I went to school a little bit.
You didn't have any land? You had no land?
No land. Where we were staying, it was belonging to Nyansa people.
So what
Here in Kericho, there was no land. We were squattering here in Majengo, next to Majengo, where now it is called the Bon area.
So what would you want the British government to do?
In fact, first of all, what I want British to do, legally, if you follow the legal. When my father and his brothers were detained, there was a legal letter or certificate showing that these people have been detained. And it was signed by Queen or Governor, something of that sort. And when we came from Wasi, there was no releasement certificate. So I consider myself, first of all, that I should be released. British government should give us certificate of releasement.
You're still in jail?
Still in jail, up to this moment I'm talking. Indirect jailment. And it affects me because I know very well that I have not been released.
What else do you want them to do for you?
I'm requesting them, not really requesting, but the question is, there was no land. The land which we were living in Kiptere, my father was staying, belongs to other people now. Now, we are requesting British government to compensate us.
I can let you know, at the end, Dixon says, as we've very much been saying today, that the lack of action is simply not good enough, and the smallest gesture, even meeting with the victims, would be greatly appreciated. There was also a bit where it jumped in the middle, and he's basically talking about his mother's arrest, which is the reason why they got sent to Gwasi from the ancestral land in Kericho. So thank you very much. If our speakers want to come back, if you have one or two questions, I might start with a question for the panel. I think something that is often asked is, why are we doing this now and not however many years ago when independence took place? I know this is something we ourselves have discussed quite a lot. So I think that would be my question. Why now as opposed to 50 years ago?
You answer the question straight away. Yeah. Okay. Thank you very much, Madam Nikita, for that question, that why are we doing it now? There are good reasons why we are doing it now, and we are not going to use the political rhetoric that an idea whose time has come or which has done cannot be resisted. You can resist an invading army, but an idea not whose time has come. Why now? First and foremost, the kind of independent constitution that we got from the British, which was coined at the Lancaster House, was what legal scholars call it adventitious constitution. A constitution which is not really a very good document, but one that gives not complete rights. It's almost like a negotiated settlement. It's only in the year 2010 that we caught what is called a homegrown constitution, that is autochthonous constitution, which was able to recognize and address historical injustices. The 1963 independent constitution in Kenya did not recognize historical injustices, but the one of the year 2010 recognized historical injustices. It also provides for devolved unit. It also provides in the devolved unit a system where counties are able to identify the specific problems that are affecting the people, and therefore seek a way forward in addressing them. And I think that is exactly what the Kericho government did. Having gotten the devolved unit, the Assembly of Kericho was able to meet and able to appreciate that there was landlessness in Kericho, there was a lot of poverty among various households, actually a vicious circle of poverty, and they could trace it to historical injustices. And that is why they were able to sit down and say, how do we address these things? You will appreciate that in Kenya, not all communities suffered land dispossession. The communities that suffered land dispossessions are the Kikuyus, not even all the Kalenjins, it's only the Nandi, the Kipsigis, the Tugens of Eldama Ravine area, and of course you also have the Sabors, the Sebis and the Pokots, and also the Maasais. But we have in Kenya about 43 or 44 tribes, but not all of them suffered that. So probably it was very difficult for the entire National Assembly to be able to pinpoint. So I think I've answered the question that the new constitutional dispensation provided an avenue for addressing this serious historical issue.
Thank you very much. That is a very important question, and I'm going to respond in this manner. In 2004, this same community attempted to petition the British government, which they successfully did by marching to the British Embassy in Nairobi and ultimately petitioning the British government. At the time, the British government thought that they would get away with it by saying that that was a matter for the Kenyan government, because the old constitution protected them. The old Kenyan constitution had no leeway for addressing historical injustices. Then step number 2 that they took was to seek legal advice on how they would successfully petition the British government from solicitors globally. And again, they had challenges because of lack of capacity. At that time, they didn't have local lawyers who would help them. But later on, when the new constitution was promulgated, it provided for an opportunity which included addressing historical injustices. But the beauty about the new constitution in Kenya is that it provides for 2 levels of government: county government and national government. This is the route which has helped the communities to address their issues, because the constitution provides for petitioning a national or a sub-national government to listen to their issues. So in 2014, the Talai and the Kipsigis communities petitioned the County Assembly of Kericho, and this is the route which then activated a search for legal counsel which would provide a roadmap for actualizing their desires to have their issues addressed. So we are here today courtesy of the new constitution. And since most victims are very poor, they could not afford legal fee. The county government of Kericho, working together both as the legislative arm of the county assembly and the executive arm, put up a budget to assist the victims get their issues sorted out through whatever route. And the route has already been highlighted by the Queen's Counsel, that it began with writing to the British government for a possibility of an out-of-court settlement, which didn't work, and these options are open. But ultimately, the route that we have taken is so that the United Nations can get to know that these people have tried and that something needs to be done to them. Thank you.
Yes, we have a question at the back.
You can come forward a little bit. Yeah.
Thank you. Thank you very much for the opportunity. My name is Tony. I work for the Commonwealth. I'm here in my personal capacity, just to make that clear, but I'm a Kenyan. So you can see the reason why I'm here. Thank you very much for the exposition. I'm a Kenyan, but I've learned a lot. You would imagine that being a Kenyan, I would already know all this, but I have learned a lot from Advocate Bosek, QC Dixon, and Professor Chepkwony. So thank you for that. Now, my question is whether you are taking a multi-pronged strategy to address this problem, because from my reading of what you've just presented, it's clear that you have to pursue both an international strategy, but also look at what is possible under the Kenyan Constitution, as you have just said. I have not heard you mention anything with Kenyan courts. Kenyan courts, are they part of the solution? Because in my thinking, the UN has a very limited ability to solve that problem. So the special rapporteur will go study the problem. He'll do a report at the Human Rights Council, but we all know that that will not bind anybody. It will not bind the British government. It will not bind the Kenyan government. It will not actually provide for compensation. The special rapporteur or the High Commissioner for Human Rights has no ability to order compensation for the victims. So the best they can do would be an advocacy role to highlight this issue to other states, to recognize that there is a problem. But where you can get reparations or compensation, or in fact, ability to get even part of the land given back to these landless people that you are mentioning, clearly lies with either Kenyan courts or the British courts. So I would, not to question your strategy, I would recommend that you really seriously consider also looking at how Kenyan courts can be involved, because we all know that under our new constitution, making a petition to the courts and arguing your case and showing that your fundamental rights have been violated is a real possibility. And as you say, these are universal human rights. We cannot say, oh, they only apply if they happened after the constitution was promulgated. You can argue clearly that these people were dispossessed of their land. It's a situation that affects a lot of other Kenyans, the Maasais, the Samburus, the Sebeis, the Tavetas at the coast. So I think you'd also be contributing to the liberation and solving of a very fundamental issue for other Kenyans as well, if you pursued such a strategy. Thank you very much.
So
thank you very much.
I was going to say both Bosek and...
Sure,
yeah.
yeah. Okay, thank you very much, Walter. No, not Walter. You said Anthony. I almost called you Walter Sisuli. Sorry. Yes, we'll say that this is a matter where you are taking the British government to court. The matter of taking the British government to court must be in the English courts. And QC Rodney has explained the hurdles that we have had in taking the British government to their own court. You will recall that the Mau Mau 2 actually could not take off because of the issue of limitation, and it appears that from the High Court, Court of Appeal and the Supreme Court of England and Wales, that was the issue, that there is limitation. But remember, the Mau Mau 2 was about personal injuries and torture. This one includes also the aspect of land. And when it comes to the aspect of land, we have gone to the National Land Commission, as Rodney Dixon QC stated, and actually there is a recommendation. First and foremost, the National Land Commission is very much alive to the fact that what we are being told is the total acreage of land is actually misleading. So the county government was given the task or the responsibility to resurvey the land, we know that this land could be probably 2.5 times what the multinationals are stating. There's also concealment of facts. And even before we took the surveyors to survey the land, a number of multinational companies went to court to block us. And there's an ongoing case in Nairobi where some multinationals have sued the Kericho, Bomet County government plus the National Land Commission, saying that whatever was decided by the commission, the recommendation was not is not something that should be adopted. But we are tussling it out, and we are hoping that we'll be able to have the entire application dismissed, because as lawyers, we know where to hit hard, and I can assure you that on the issue of land, I am 90% very optimistic that when the survey is done, what the National Land Commission said is that whatever acreages that are over and above, that one should go to the community through the county government as trustees directly. That's number one. Number two, the multinationals be allowed a lease of probably up to 90 years, from this year, to remain as tenants, but not tenants of the national government of Kenya, but tenants of the county governments. And as tenants, they are obliged to pay rent at a commercial rate, not to use the 1915 rates that they have been using so far, 1915, before we even became a colony, not to use figures that are very, ridiculous. They were also told that they have to pay rates at the commercial rate. For a very long time, they were playing around with figures, like 2.5 acres, which is actually like 1 hectare. The multinationals will actually say that the value of that land will be like 800,000. But today, we know very well, and the governor will confirm this, that the land they are sitting on, when it was being compulsorily acquired, 10 acres was being acquired for a water project. That is when they came up with the valuation that 1 acre is 10 million. So I think governor will answer that as to what steps, because the National Land Commission recommendation is that steps must be taken, and must be taken within 3 years. So that's something that we are going to actualize. On the issue of land, that one we'll fight tooth and nail to ensure that we actualize it, because it is for the good of the people. But there are these things of what is called in law mean profit. Normally it is spelled mesne, as though it is mesne profit, but it's mean profit, which the National Land Commission is also saying the British government and the multinationals ought to pay the local people. That is what we are pursuing. We are also pursuing issues to do with torture. We are pursuing issues to do with cruel and degrading treatment. And we are saying all those things, we cannot address just one aspect, and that is the land aspect, which, as I said, the Kenyan courts are involved in it. And let me say this, that we were very much happy when the Attorney General also joined us to say actually the court, the multinationals had filed that case, does not have jurisdiction, because in Kenya we have the Environment and Land Court. But they went to the ordinary courts. And that is the strategy they were doing even during colonial times. Instead of the Kericho station, High Court station, has both Environment and Land Court and also the ordinary courts. But when you read in the materials in the archives, the multinational tea companies and their lawyers have always been saying that let not file anything in Kericho because it will attract local attention. That has been their strategy. But today we are telling them that it's no longer a local matter. It has become a global matter. So thank you very much, Walter. We are adopting, not Walter. I don't know why I'm baptizing you. It's Sisuli. You say it's Sisuli, isn't it? Sisule. Sorry about that. Thank you. And let me say this. We are adopting a multi-pronged approach in this.
Briefly, I mean, and in short, we have to pursue every single avenue here. But you don't want to go down rabbit holes that are going to get you absolutely nowhere. The problem with the UK courts at the moment is on the limitation issue. Now that may be challengeable, maybe in certain cases. It might mean that you can't do every case, you have to select some. And we therefore have that as a backup, that we could go after certain cases where we'd have the best chance of succeeding. But in order to meet the expectations of the entire client group, very hard to do that through the UK court because of the limitations that have been imposed. And there might be very particular reasons why they have been imposed, but difficult to challenge purely in court. That's why one has to look broader than that and take it to the international level, because this is one of the first times that a matter like this is coming to the Special Rapporteur, and we think that could have positive ramifications. And having it opened up at that level could provide the catalyst for a resolution, together with doing many other things as well. I think the Kenyan court certainly can be looked at, because the recommendations have to be implemented. If they're not, then legal action could be taken there. There are other forums as well. There's the European Court on Human Rights, which might have a jurisdictional reach in this situation. So all of those are there, and it is vital to pursue every one, in the hope, of course, that the matter can be settled before then, because it will be protracted, it will be difficult. The victims want it addressed now. Many of them are very old as well, and that's what we're trying to, through this process, encourage the parties to do, to show the real value of not fighting it out endlessly in court, which will just be a protracted dogfight. Rather look at being proactive and constructive and sort it out for longer-term benefits for all parties.
Maybe just to add to what the councils have said, the recommendations of the National Land Commission are to be acted upon by the governments of Bomet, county governments of Bomet and Kericho. And these are the two counties where you have the Kipsigis and the Talai. And all the 10 recommendations must be implemented within 3 years. I would like to say that as the two governments, we are already beginning the implementation process, and we will implement them in total. For example, shortly, we will be informing Unilever, Finlays, and Williamson that we want to resurvey the land, and any excess land which they've been owning over time has to be returned to the county governments of Kericho and Bomet to be held in trust for the people. Second, we are already working on a valuation role in which now land levies will be at commercial rates. Number 3, we are also in the process of ensuring that the recommendation, especially on this excess land, is not just on excess land, but on total acreage, which actually should be due. Apparently, it does seem like they only declared land under T. And land where there are houses, fuel trees like blue gum and riparian areas are not declared. So this total land area we are going to resurvey and disclose it to public. And any land that they've been owning over and above what they should, they have to pay at commercial price, at commercial rates. Then the other thing is they need to return the title deeds to the county government so that now they can be given new title deeds reading county government of Bomet and Kericho, in which new leases now will be prepared for them, because the old leases were under the crown. So these are some of the issues that we are going to implement immediately, and that is why we are very serious. Thank you.
Thank you very much. I think we're going to have to stop it there because we've got to get a flight to London. But there's food, so please help yourselves. And I'm sure if you have any other burning questions, we will be around to answer those for the next half hour or so. So thank you very much for coming today, and thank you to our speakers and to the Geneva Press Club for hosting us here today. Thank you.